What is lawful processing of personal data? First of all, it's worth mentioning that the definition of personal data is changing. The GDPR's definition is more detailed than the Data Protection Act and is broad enough to potentially include personal identifiers such as IP address and even pseudonymized data. For the marketer, a major part of the GDPR compliance is determining whether processing of this personal data is lawful. There are 6 lawful bases for processing personal data listed in Article 6 of the GDPR. Some of these are relevant only to highly regulated industries and public authorities, but there are 2 in particular which are pertinent to the general marketer. The first of these is processing with the consent of the data subject. This is the classic tick box scenario that consumers are familiar with. The GDPR sets out some detailed criteria for what consent should look like, and we'll cover these in the 5 aspects of consent module. The second lawful basis of note for marketers is where data processing is necessary for the purposes of legitimate interests pursued by the controller or a third party, except where such interests are overridden by the interests, rights or freedoms of the data subject. There has been debate about exactly what marketing activity can be deemed a legitimate interest. We'll look at this too in the What are legitimate interests module. The lawful basis you decide upon for data processing needs to be documented. This is particularly important under the GDPR because it will have an effect on the rights of individuals. If you rely on someone's consent to process their data, for example, they will generally have stronger rights, such as the right to have their data deleted.